Hello, I'm Katie Dyers and I'm a Senior Associate in the Employment Team here at Goodman Derrick. Directors owe a number of duties to the company, and many of those duties are set out in the Companies Act 2006. We had a look at these duties in our previous podcast, but the aim of today's podcast is to bring these duties to life with a look at a case brought by a company called Richmond Pharmacology against one of its shareholders, Chester Overseas Limited, and also against two of its directors, Milton Levine and Larry Levine. Now, this was a High Court case heard in 2014, and to give you a bit of the background, Richmond, the company, was formed by three doctors in 2001. In 2002, Chester became a 44% shareholder of Richmond. Now, what's interesting to note is that Chester's shareholders were some trustees who held shares for the benefit of the families of Milton and Larry Levine. And so Milton and Larry Levine were appointed as directors of Richmond, and it was acknowledged that the Levines were directors nominated by Chester so that they could take Chester's interests into account. However, that was subject always to their directors' duties and the terms of the shareholders' agreement that was put in place between the founders and Chester. All went well with the relationship until about 2008, when there was a dispute over some software. By mid-2008, the falling out had escalated to such a degree that the Levines wanted to end the connection by selling Chester's shares in Richmond. In June 2008, the Levines instructed a company called New World Corporate Finance Limited to assist them with selling Chester's shares. A non-disclosure agreement was signed, and the Levines sent over a large amount of confidential information about Richmond's affairs to New World Corporate Finance. As a result of their advice, there was some MBO, some management buyout discussions that took place, but unfortunately they were unsuccessful. So by early July 2009, Chester was seriously considering the idea of a sale of its shares to a third party. With this in mind, more confidential information was emailed over by the Levines to New World Corporate Finance. By late July 2009, there was a meeting between New World Corporate Finance, Chester, and the founders. At this meeting, the founders emphasised the need for strict confidentiality, stressing that there was a need for the business to remain stable and competitive, with a good reputation for both financial and managerial stability. In October 2009, the Levines purposefully obtained more information from the finance director so that they could forward it on to New World Corporate Finance to advise them further about their sale to third parties. On the 26th of October, the Levines formally advised Richmond at a board meeting that New World Corporate Finance would be offering Chester's shares to the market on behalf of Chester. Now, because of the potential dispute regarding confidentiality and the discussions at that board meeting, the Levines subsequently instructed New World to only use information that was publicly available. I've set out on the slide the marketing process. In November 2009, New World Corporate Finance marketed Chester's shares in Richmond. They contacted over 80 potential purchasers. 13 of them were given Richmond's name during the initial telephone call, and 8 were issued with a non-disclosure agreement. Only 3 signed that agreement, and they were sent a teaser document which included a little bit more information about Richmond. As a result, there were 2 meetings with potential purchasers. One of those meetings went nowhere, and the other, there was some discussion and more information was obtained by Larry Levine from Richmond's finance director, which was then in turn provided to New World Corporate Finance, who emailed it to the potential purchaser. However, ultimately the discussions failed and the purchaser was no longer interested. Another important point to note about the marketing process was that during the marketing exercise, New World Corporate Finance made some comments to potential purchasers like, "I can confirm this is an opportunity to buy the whole of the business," rather than making it clear that it was just Chester's shares that were for sale. By January 2010, the marketing efforts had ended and there were no other potential purchasers that they could explore. As a result of that, in February, Chester served a notice of deadlock on the founders. This was a mechanism under the shareholders' agreement, and it provided that the company would be wound up unless the situation was resolved within a certain time frame. In March 2011, Chester also made an application to the court alleging unfair prejudice. They tried to keep the option open that the founders would be forced to buy Chester's shares in Richmond as an alternative to winding up the company. Now, as many of you will know, when engaging in litigation, there is a disclosure exercise, and as part of that disclosure exercise, documents were provided by Chester to Richmond. Richmond and the founders discovered that there had been many breaches by Chester and the Levines with regard to the confidential information that they had provided to New World Corporate Finance and the potential purchasers. And those allegations then led to this High Court case that we're currently looking at. In summary, Richmond claimed that its confidential information was unlawfully disclosed during the course of the marketing carried out by New World Corporate Finance on behalf of Chester, and that a misleading impression had been given that all of Richmond's shares were for sale, not just the shares held by Chester. They said that this caused a substantial loss of business, and they claimed almost £4.3 million as compensation. Richmond brought claims against Chester, the shareholder, and also the Levines in their individual capacity as director. Now obviously we're looking at directors' duties, so we're looking at what the High Court analysed. We're looking at directors' duties, and the High Court closely looked at 4 particular duties that are set out on the slide. So the key question is, was there any breach by the director? So we'll look at these each in turn. The first duty was Section 172 of the Companies Act 2006, which is to promote the success of Richmond for the benefit of the members as a whole. Now this duty is only breached if a director acts in bad faith. The court found that the Levines did not act in bad faith. They were open about their intention to market the shares and disclose information to potential purchasers under a non-disclosure agreement. So in short, they were careful to control the flow of information about Richmond, and therefore the court found that there was no breach. The next duty was Section 174 of the Companies Act 2006, which is to exercise reasonable care, skill and diligence. To consider this, the court looked at both the general knowledge, skill and experience that can reasonably be expected of a person carrying out the functions that were carried out by the Levines, so the objective test, and also the general knowledge, skill and experience that the Levines actually had, the subjective test. They concluded that Chester had been entitled to market its shares in the way that New World marketed them, and that they had taken considerable care about ensuring that confidential information remained confidential. So the court concluded that for this duty there was no breach. The third duty that was analysed by the courts was Section 175, to avoid a situation in which the Levines had a direct or indirect interest that conflicts or may conflict with the interests of Richmond. Now the Levines had always been authorised by the founders to act as representatives of Chester, even though there was the potential for conflict of interest. But as I said earlier, this was always subject to them acting in accordance with the terms of the shareholders' agreement. So the court analysed whether there was any breaches of the shareholders' agreement. They concluded that Chester was permitted to disclose confidential information to its professional advisors. So when the Levines emailed information over to New World Corporate Finance, that was fine. However, when New World Corporate Finance disclosed that information to the potential purchasers on Chester's behalf, that was a breach. The courts acknowledged that the information disclosed did not give the receiver any advantage over Richmond, but it was still a disclosure of confidential information. The court also concluded that by telling prospective purchasers that all the shares in Richmond might be available for sale, there had been a further breach of the shareholders' agreement, because that was a disclosure of commercially sensitive information. The courts recognised that it was only Chester's shares that were for sale, and therefore the information provided was untrue. However, that did not make any difference to their findings. The court also made it clear that there was no defence that the Levines had been acting in good faith, or that they had reasonably but mistakenly thought they were entitled to act in the way that they did, and therefore the court found that this duty had been breached. Additionally, the courts also found that there had been a breach of the equitable duty of confidence. Now you might recall that Chester had claimed losses of over £4 million. However, the court found that none of the breaches, whether contractual, statutory or equitable, had caused any actual loss to Richmond, and therefore they only awarded nominal damages of £1. Now, it's important to note that compensation might not always be so minor, and certainly this case should not be taken as an indicator that directors can breach their duties and effectively get away with it. Awards of compensation can be very costly. There can be some situations where a director is disqualified from being a director in the future, or even prosecuted on a criminal basis. Thank you for listening. My details are on the slide if you have any queries or would like legal advice on this subject or any other aspect of employment law. Please do also connect on LinkedIn and our other social media channels. Thank you again for listening, and look out for our other podcasts on directors' duties.